Your Honor, the eighth appeal person is not in court. Pursuant to what is happening in this matter. Out of, I don't know, 10 or 15 accused persons, the court has been served with High Court orders stopping their plea taking. All those who have provided the High Court orders fall into the category of professionals, architects, valuers, and the judge has agreed that trying professionals when they are discharging their matters is unconstitutional, and that's why those plea taking has been deferred. The eighth accused person falls in that category. Number two, Your Honor, he wrote a letter to the DPP. In writing, he sought for review. The DPP has a mandate to write to him, either declining with reasons. That is the constitutional provision under Article 47. It compels even the president, whenever he is doing something, he does it in writing. The ODPP is not excluded from that. Courts make judgments supported by reasons. Your Honor, this is different from a traditional chief's office where decisions are made orally. That is why the accused are brought to court with a written charge sheet. So Your Honor, we'll be seeking that the plea be deferred for the accused person until the DPP reviews his application under Article 157, Article 11, and gives reasons as to what made the DPP make whichever decision. You know, the import of giving the DPP power to review the framers of the Constitution wanted to unclog the judicial review of the High Court. That article, Your Honor, gives the DPP an appellate jurisdiction over their own decision. While courts, after decision has been made, are functus officio, the DPP has those constitutional instruments. The DPP cannot run away from the mandate given to his office by 55 million Kenyans. Does the writing for review constitute a stay of the proceedings? The state will argue that the only thing that stops these proceedings is a stay order from the High Court. You know, the 8th accused person wrote to the DPP long before this matter came to this court. In order to promote efficiency and being responsive of public officers, we urge the court to give the DPP timelines. They make that decision tomorrow, or they make that decision next week, and our client will come and take plea if the DPP has complied to Article 47 of the Constitution. The reason why the courts can issue timelines to the DPP is to ensure that justice for accused persons is protected. We are not asking the court to order the DPP, but the court has jurisdiction to issue timelines for that decision to be brought before this court. Will the deferral of plea be prejudicial to the state? The state will not be prejudiced by any issue. Will the taking of plea be prejudicial to the accused person? Yes. As a public servant, if he takes plea, he's interdicted. When the state or when the DPP reviews and says he's not supposed to be part of the accused person, can that decision atone for the damage caused by a civil servant? It will not repair the damages and the prejudice that the accused number 8 is likely to face. You know, we came from an era where the prosecution's mandate was simply to convict. The 2010 Constitution mandates the state to ensure justice for both the accused, witnesses, and the complainant. We are alive that this is a matter of public interest. But Your Honor, in the Dr. Murungaru case, the judges said they cannot move because the public wants people convicted or taking plea. And they stood firm and said provisions of the Constitution must be followed. Your Honor, and I'm definite that these are those matters that normally there is a lot of hype when taking plea. Later, the state discovers there is Section 87A. They withdraw all these matters. Because they are time specific. Charge them to please certain quarters. After that, the accused will rot in this court until Section 87 is involved. You and I plead to the court to defer the plea for the 8th accused person and issue timelines for the DPP to write to us. If he writes to us in a few minutes now saying we have declined, the accused will be the law. My other associates can, Mr. Murunga and Kinyanjui, Martina can reinforce our arguments.
You don't allow me to just add two things. One is that the letter that Mr. Omari has referred to.
From the JR Division of the High Court, we can have the matter mentioned on the 21st of October 2026 to confirm the status in respect to their JR petitions and to enable the court to give further directions. In respect to the 8th and 9th accused persons, they have not attended court for plea. For the 8th accused person, his counsel have argued that the reason for non-attendance is twofold. Firstly, the 8th accused person had written to the ODPP for a review of the charges, and the same is yet to be responded to. The defense counsels have argued that it will be prejudicial for the 8th accused person to take plea before this response has been given, since as a civil servant taking plea will have him interdicted, whereas if plea is deferred, there will be no prejudice to the state. Secondly, the court has been notified that the 8th accused person is still indisposed and admitted in hospital. The defense has intimated that documents evidencing the same have been filed in the CTS platform and subsequently served upon the ODPP via email, and the defense has invited the IO to verify the said documents. In respect to the 9th accused person, his counsel has notified the court that he's absent since he had also written a letter to the ODPP for a review over the decision to charge, and the same is yet to be responded to. Further, they have filed an application for the 9th accused person to have a separate trial, but are yet to serve the said application upon the prosecution since there was a system lag. The court has also been informed that the 9th accused person is still unwell. In response, the prosecution has indicated it has no qualms with the accused persons who have obtained the stay orders from the High Court, but in respect to the 8th and 9th accused persons, the prosecution has reiterated its earlier application for a warrant of arrest to be issued against them. The prosecution has maintained that writing letters for review of the charges cannot operate as a stay. The prosecution has also faulted the counsel for the 8th accused persons for failing to avail the hard copies of the documents today, yet they were aware the matter was coming up in court. With respect to the 9th accused person's application to have a separate trial, the prosecution has maintained the same cannot be made when the accused person is yet to take plea. The court has considered the respective positions of all the parties. Starting with the 8th accused person, the defense has asked the court to order the prosecution to give a response to the decision to charge in writing before plea is taken. The prosecution maintains that the review on a decision to charge is continuous and cannot be used as an avenue to prevent an accused person from taking plea. In this case, I do appreciate that the eighth accused person taking plea may prejudice his work. However, ordering that plea cannot be taken before the prosecution responds in writing on his application for review will be akin to the court staying prosecution of the eighth accused person and ordering the ODPP on how to perform its mandate. Procedurally, once the ODPP makes a decision to charge and brings a charge sheet to court, the review is done during the pendency of the proceedings. Indeed, the defense has admitted that the other accused persons, who are also professionals, have gotten stay orders from the High Court. I do believe if the eighth accused person wants this proceeding stayed pending his review on the decision to charge, the right avenue will be also to obtain stay orders from the High Court. The court has considered the second reason for the non-attendance of the eighth accused person, which is that he is still indisposed and admitted in hospital. The defense has uploaded the medical documents in the CTS portal and invited the IO to verify the same. Although the prosecution argues that physical copies ought to be availed in court, as long as there is no argument that there are no such documents uploaded in the CTS, I do believe the judiciary introduced the CTS platform to ensure efficiency and expeditious disposition of justice, and any document uploaded in the CTS is deemed to be a valid court document, as earlier observed on the 20th of July 2026, where an issue is raised that an accused person is indisposed on account of illness unless there are no medical documents or the documents provided are verified and found not to be authentic, the court cannot in good conscience issue warrants for arrest. It is for these reasons only that the court declines to issue warrants of arrest for the eighth accused person. The court may, however, review these orders should the documents be authenticated by the IO and found not to be genuine. In respect to the ninth accused person, as earlier noted, a letter for review of the decision to charge or an application to have a separate trial cannot operate as stay of proceedings. On account of illness, the court notes that the ninth accused person was also absent on the 20th of July 2026, and the court ordered for medical documents to be availed. Today he is also absent. No medical documents have been availed in court to evidence his indisposition. Until the same are availed, warrants of arrest to issue against the ninth accused person. So we can take directions in respect to pre-trial. Have the documents been served for the accused number 1 to 4?
They served shortly. The IO is preparing an event.